Hello, my name is Beth Mulcahy, and I am the managing partner and senior attorney of the Mulcahy Law Firm in Phoenix, Arizona. Mulcahy Law Firm represents thousands of planned communities and condominium associations throughout the state of Arizona. 2019 was one of the longest legislative sessions this decade, and 8 new laws pertaining to community associations were passed this year. Here's a quick summary of the most important things board members, managers, and homeowners need to know about the new laws. Senate Bill 1531. There are 3 parts to this new law. This law increases the association's time to enforce a lien for an owner's unpaid assessment from 3 to 6 years. What does this mean for your association? Your association can now foreclose an assessment lien on an owner for up to 6 years of unpaid assessments. This is a positive development as it allows the association the opportunity to collect more money through a foreclosure lawsuit. Moving on to the next part of this law, specific actions must now be taken by an association before turning over a delinquent owner to a law firm or a collection agency for collection action. This means prior to asking an attorney or collection agency to assist you in collecting delinquent accounts, you will be required to do the following. Send a written notice to the owner at their address on record regarding their unpaid assessments at least 30 days before turning the account over to a law firm or collection agency. The notice sent to the owner must include this exact language in boldface type or all capital letters. Additionally, the notice, which must be sent by certified mail, return receipt requested, must include the contact information for the association's representative that the owner should contact to discuss payment. Beginning January 1st, 2020, the association shall provide a statement of account in lieu of a coupon book to the members with the same frequency that assessments are provided for in the declaration. The statement of account shall include the current balance due, and the immediately preceding ledger history. An owner may opt to receive this statement electronically. Because of this requirement, I highly recommend that your association review the assessment portion of your CC&Rs to determine the frequency at which the statements must be sent. Your association may want to consider adding an amendment to your CC&Rs to provide clarification and comply with the new law. The association may stop providing statements to an owner if collection activity begins. For example, if a delinquent account is turned over to a law firm, the association no longer needs to send a statement. At that time, an owner may request statements of account by written request to the attorney or collection agency. If an owner whose account is with a law firm or collection agency requests a statement of account, then the association's law firm or collection agency should handle. The statement of account provided by the attorney or collection agency responsible for the collection shall include all amounts claimed to be owing to resolve the delinquency through the date set forth in the statement, including attorney's fees and costs, regardless of whether such amounts have been reduced to judgment. The law firm or collection agency can charge a convenience fee for accepting payments by credit, debit, or other electronic means. Senate Bill 1309, Renewal of Judgments. In 2018, the legislature increased the amount of time to renew a judgment from 5 to 10 years. This year, the legislature provided clarification. Any judgment entered after August 2, 2013 is valid for 10 years from the date the judgment was entered. Any judgments entered prior to August 2, 2013 that were not renewed before August 2, 2018 are considered expired. House Bill 2151, Satisfaction of Judgment. This new law mandates that a satisfaction of judgment be filed within 40 days of the judgment being satisfied. If the satisfaction is not filed in that time period, then the opposing party may file a motion to compel a satisfaction of judgment. If the court grants the motion to compel, then the judgment is deemed satisfied. A judge may compel the moving party to post a bond with the court in the amount of the judgment. More so than ever, it will be important for associations to communicate with the association's law firm or acting representative regarding payments received so judgments can be timely satisfied under this new law. A protocol should be initiated to confirm satisfaction of judgments are being filed within 40 days of satisfaction. This new law applies to small claims court, justice court, and superior court judgments. House Bill 2672, Vacation Rentals, Short-Term Rentals, Regulations. Over the past few years, there has been a dramatic increase in the number of rental properties, including short-term vacation rentals in Arizona. As background information, in 2016, the legislature adopted a law that prohibited cities, towns, and counties in Arizona from restricting short-term rentals, with the exception of a few purposes, such as the protection of the public's health or safety. However, the changes in the law in 2016 did not prohibit an association from regulating the use of short-term rentals. Many associations passed CC&R amendments limiting or prohibiting short-term rentals in response to this 2016 law. The 2019 law adds a requirement that the owner of a short-term rental property provide the city, town, or county with contact information for the owner or the owner's designee who is responsible for responding to complaints in a timely manner before offering to rent the property. In addition, the 2019 law states that a short-term rental may not be used for non-residential uses, including for special events, retail, restaurant, banquet space, event center, or other similar use. There are 4 other laws passed in 2019 by the Arizona legislature that apply to community associations. These 4 laws have limited applicability, so I won't be going into them in detail on this video, but I would like you to be aware of them. To obtain a copy of our law firm's 2019 Legislative Update Cheat Sheet with a summary of all 8 new laws, please visit our website at mulcahylawfirm.com or contact our office at 602-241-1093 and we'll mail or email you a copy of this cheat sheet at no charge. Please contact our office if you have any questions regarding the new legislation or any other legal question pertaining to community association law. Thank you.